Welcome to Daily News Simplified, an answer to what, why, and how of newspaper reading. Today, we are going to discuss the Delhi edition of Hindu newspaper dated 11th May 2018. Let's begin. Now, the first news appears on page number 1. It reads Supreme Court Collegium to meet today. And this news also appears as a continuation on page number 10, where same thing has been discussed in detail. Now, in this news, the Supreme Court Collegium shall be meeting today for the discussion of elevation of High Court Chief Justice of Uttarakhand, Justice K.M. Joseph. Today, the Collegium shall also be discussing names of judges from Calcutta, Rajasthan, and Telangana and Andhra Pradesh High Court for the purpose of elevation as Supreme Court judges. And today, if the Collegium confirms its decision on these judges to be elevated, including Justice Joseph, then it shall have a binding effect on the government. So let us understand this entire issue with respect to Collegium and the role of judiciary as well as the central executive with respect to primacy of their opinion as well as having a binding effect. As you must be reading in the newspaper regarding the controversy arose when the central government reverted back the name of Justice K.M. Joseph for reconsideration by the Collegium. Now, you must be thinking whether the central government has the power to revert back certain decision of the Collegium or whether this Collegium has to obey as per the dictum of the central government. So let us understand this entire issue as well as the controversy with respect to certain backdrop and also understand whether judiciary or the central executive have any role with respect to their opinions given on the appointment of these judges. You know that judges to the Supreme Court and High Court are appointed by the President of India as per the Indian Constitution. However, the method and manner of their appointment to higher judiciary has not been explicitly provided by the Constitution. Thus, the process for appointment, elevation, and transfer of judges to higher judiciary has been a debatable issue. And due to the interfering nature of the central executive, this entire process of collegium erupted through, as we all know, the three judges case. So let us understand a slight backdrop about this entire process of collegium and how it impacted the issue of interference by the central executive. First of all, let us understand what a collegium is. A collegium system is one where the Chief Justice of India and four senior most judges of the Supreme Court recommends appointment and transfer of judges to higher judiciary. As discussed, the collegium system has evolved through three different judgments which are collectively known as the three judges case. So with respect to these three judges case, the whole issue erupted due to tussle between the executive and the judiciary and the entire concern was which of them, that is the executive or the judiciary, shall have primacy with respect to their recommendations. So prior to the development of this concept of collegium, earlier power to appoint Supreme Court judges rested primarily with the executive. The practice was to appoint the senior most judge of the Supreme Court whenever a vacancy occurred by the executive. In 1973, the Union government departed from this practice of appointing the senior most judge and appointed Justice A.N. Ray as the Chief Justice of India, who was fourth in order of seniority, and this effectively by bypassing three senior most judges. By this appointment, the government was accused of tampering with the independence of judiciary. Again in 1976, the government of India appointed Justice Beg as Chief Justice of India, bypassing Justice Khanna, who was senior to him. So, we saw for the first time in 1973 as well as 1976, this interference by the executive and judicial appointment occurred. Now, through these three judges' case, this entire issue of interference as well as primacy was settled. So let us understand how the collegium evolved through these three judges' case and how the primacy with respect to this appointment of judges rested primarily with the central executive and then later on with the judiciary. Now, S.P. Gupta versus Union of India is considered as the first judges case. Here, the main question before the court was as to whose opinion among the various participants should have primacy in the process of selection of judges. The Supreme Court held that opinions of Chief Justice of India and Chief Justice of respective High Courts were merely consultative, and the power of appointment resides solely and exclusively with the central government. Thus, effectively, as per the first judge's case, central government could override the opinion given by judges. However, in 1993, in the second judge's case, the court emphasized that the government does not enjoy primacy or absolute discretion in matters of appointment of Supreme Court judges. Thus, in the second judge's case, the Supreme Court reduced the role of executive in appointment process so as to reduce political interference. Thus, for the first time in the second judge's case, the primacy was shifted from the executive to the judiciary. And the third judge's case, this primacy of judiciary was laid down in strict guidelines. And it was from the third judge's case that the entire concept of collegium emerged, where it was stated that the Chief Justice of India shall consult four senior most judges of Supreme Court while elevation or transfer of judges of higher judiciary. And this opinion of members of collegium shall be in writing. It also stated that if the majority of the collegium is against the appointment of a particular person, that person shall not be appointed. So we understood that after the first judge's case, the primacy was with the central executive, and in the second judge's case, this primacy got shifted from the executive to the judiciary, and in the third judge's case, this primacy was laid down as guiding principles and the entire concept of collegium emerged, which comprises of Chief Justice of India and four senior most judges of Supreme Court. Now, with respect to the current scenario of elevation of Justice Joseph, this is what happened. First, judiciary recommended the name to the central executive. Central executive had certain reservation with respect to Justice Joseph. Now, again the central executive has reverted back the name of Justice Joseph back to the collegium for reconsideration. Today, as we can read in the newspaper, that the collegium is meeting again. So, if today the collegium finally decides that Justice Joseph or any other judges are to be elevated, then as per the decision of collegium or the third judge's case, this decision of the collegium becomes binding on the central government, and the central government has to appoint that judge as judge of a Supreme Court, and such appointment shall be made by the President of India. So, in this news, it becomes important to understand this issue of primacy of opinion between the central government or the central executive as well as between the judiciary. Remember that the appointment has to be made by the President, but who shall be appointed is a decision which has to be taken by the collegium, and such decision of the collegium shall be binding on the central executive. I hope with this analysis you are clear with this concept of collegium and the role of executive as well as judiciary in the entire process of appointment of judges and the current controversy which is going on with respect to elevation of Justice Joseph. With this, let's move on to the next article. The next news appears on page number 3. The news reads, NHRC, that is National Human Rights Commission, asked Orissa government to pay 6 lakhs rupees to victims of witchcraft. Now in this news, let us understand the role of NHRC and how it involves other institutions in protecting human rights or safeguarding human rights. Before going through the topic on NHRC, let us first see this question asked in the year 2014 in the mains examination. National Human Rights Commission in India can be most effective when its tasks are adequately supported by other mechanisms that ensure accountability of a government. In light of the above observation, assess the role of NHRC as an effective complement to the judiciary and other institutions in promoting and protecting human rights standards. So in this news, let us understand about NHRC, its constitution, and what are the powers and functions provided to the NHRC by a statutory law. Now this Protection of Human Rights Act 1993 constitutes National Human Rights Commission, State Human Rights Commission, and Human Rights Courts. Since this news pertains to NHRC, so let us understand how NHRC is constituted and what are the powers and functions of NHRC. As you can see, under the Protection of Human Rights Act 1993, the central government shall constitute a body to be known as National Human Rights Commission to exercise the powers conferred upon and to perform such functions as assigned to it. Now let us understand the constitution of this NHRC. It says NHRC shall consist of a chairperson who has been a Chief Justice of a Supreme Court, that is Chief Justice of India, one member who is or has been a judge of the Supreme Court. One member who is or has been the Chief Justice of a High Court. So, a member of the Supreme Court and a member of a High Court. And two members to be appointed from amongst persons having knowledge or practical experiences in matters relating to human rights. Now, this chairperson of National Commission for Minorities, National Commission for Scheduled Caste, National Commission for Scheduled Tribe, as well as National Commission for Women shall be deemed to be members of the NHRC for the discharge of functions as provided under NHRC. Now, the chairperson and members shall be appointed by the President of India by warrant under his hand and seal, and such appointment shall be made after recommendation of a committee. The committee shall consist of the Prime Minister as the chairperson, the Speaker of the House of the People as member, Minister in charge of Ministry of Home Affairs in the Government of India as another member, Leader of Opposition in the House of People as member, Leader of Opposition in the Council of States as member, and Deputy Chairman of the Council of States also as member. So, all these members shall participate and give their recommendations with respect to appointment of members as well as chairman of NHRC. It further says that no sitting judge of the Supreme Court or sitting Chief Justice of a High Court shall be appointed except after consultation with Chief Justice of India. So, this is with respect to the appointment of chairperson and members by the President and after being made after recommendations of a committee. The chairperson or any other member of NHRC may by notice in writing under his hand addressed to the President of India resign his office. Regarding the term of their office, every member or chairman shall hold office for a term of 5 years from the date of their appointment or until they attain the age of 70 years, whichever is earlier. And such member shall be eligible for reappointment for another term of 5 years. And on ceasing to hold office, a chairperson or a member and shall be ineligible for further employment either under the Government of India or under the government of any state. With this, let us also understand the functions and powers of NHRC. National Human Rights Commission can inquire into any cases either on its own or on a petition presented to it by a victim, or also on a direction of any order of a court of law. They can inquire into any violation of human rights, negligence in prevention of such violence by a public servant. NHRC can intervene in any proceeding involving any allegation of human rights. Members of NHRC can visit any jail or other institution which is under the control of the government where persons are detained or lost for purpose of treatment, reformation or protection. Members of NHRC can review the safeguards provided to a victim of human rights violation by the Constitution or under any laws of the land. The members of NHRC can study treaties, other international instruments on human rights violation and also make recommendations for their effective implementation, and in the process can also undertake and promote research in the field of human rights. Thus, through all these processes, that is promoting research and studying treaties, the NHRC and its members can also recommend the government for effective implementation of certain policies regarding with respect to protection of human rights violation. Now let us understand about certain powers of inquiry as well as investigation provided to National Human Rights Commission under this Act. National Human Rights Commission, while inquiring into any case, shall have a power of a civil court while trying a particular case, and in the process can summon the witness for examining them on oath. They have powers with respect to discovery and production of any document. They have power with respect to receiving evidence on affidavits. They can ask for any public record or copy from any court or office and can examine witness or documents. The Commission shall submit an annual report to the central government and to the state governments. And the central government as well as respective state governments shall cause the annual and special reports of NHRC to be laid before each House of Parliament as well as their state legislature, along with a memorandum of action taken or proposed to be taken on such recommendations of NHRC. Thus we see the Protection of Human Rights Act 1993 has given the National Human Rights Commission certain powers as well as functions, and its role in the society becomes very important as it provides as a safeguard on protection of violation of certain rights. So it becomes mandatory for NHRC to take help of various institutions in the government involving mainly the administrative mechanism so as to ensure protection of these human right violations. Thus, in this news analysis, we saw at length about NHRC, how its members are constituted, its functions, as well as powers. With this, let's move on to the next news. The next news appear on page number 7. The news reads, Need rules to balance out digital media. This news is about 15th Asia Media Summit 2018. And this 15th Asia Media Summit is being hosted by Ministry of Information and Broadcasting, jointly with Indian Institute of Mass Communication and Broadcast Engineering Consultants India Limited. The theme of this 15th Asia Summit is Telling Our Stories, Asia and More. And this theme aims to encourage dialogue and cooperation in the media sector in the entire Asian region. The Asia Media Summit is an annual summit of the Asia Pacific Institute for Broadcasting Development in Kuala Lumpur, which is the capital of Malaysia. India is holding the 15th Asia Media Summit for the first time. As mentioned earlier, the purpose of this media summit is to encourage regional and bilateral dialogue and sought cooperation among nations to respond to challenges to the broadcasting sector in the region. In the ongoing summit, the Government of India has reiterated that freedom of media is an integral to our political setup, and also a free and an unbiased media reflects the contemporary realities of our times. Thus, it becomes very important for our media to be free and unbiased. And this freedom of the media is also recognized by the Constitution of India under Article 19, Clause 1, under the concept of freedom of speech and expression. And it is in this respect the government further reiterated that media has full right to inform, circulate, criticize, advise, and counsel. However, the government also reiterated that under the Constitution, media is also subject to certain reasonable restriction. Thus, this topic of 15th Asia Media Summit becomes important not only because of the fact that it is for the first time this summit is being held in India, but also because that the purpose of this summit is to encourage regional and bilateral dialogue and cooperation among nations to respond to challenging times with respect to the broadcasting sector. And also, it's important to understand that the Government of India in this ongoing summit has reiterated that freedom of media is integral to our political setup, and media has full right to inform, circulate, criticize, advise, as well as counsel the citizens with respect to various schemes and policies of the government. Thus, this topic becomes important from UPSC point of view, and it gets covered under the syllabus of GS paper 2. With this, let's move on to the next news. The next news appears on page number 8. The news reads Pokhran 2, 20 years later. In this news, the author seems to suggest that the nuclear liability law and the Fukushima nuclear disaster have changed the entire outlook on India's trade on nuclear energy. We know that India conducted a nuclear test in Pokhran in the year 1998, and post Pokhran test in 1998, various sanctions were imposed on India by US and other countries. So, things on agenda of US after Pokhran test were primarily to get India signed NPT, Non-Proliferation Treaty, as well as the CTBT, that is Comprehensive Test Ban Treaty. However, India did not yield to America's demand. India refused to sign CTBT but declared a moratorium on further nuclear testing. And in this respect, India also declared no first use doctrine. After this, over years of negotiation and understanding between India and the United States led to the civil nuclear deal between India and the US. And because of this particular civil nuclear deal led to the enactment of the Civil Liability for Nuclear Damage Act 2010. Now this particular act provided for the liability of both, that is both the operator as well as the supplier. This is what has halted most of India's nuclear trade after coming into effect of this particular law, as suppliers fear that they have to pay certain civil liability or compensation in case of any nuclear disaster. Now post 1998's Pokhran test and the subsequent nuclear deal with the US brought India to the nuclear mainstream and eventually opened up global nuclear market for development of nuclear power effectively without signing the NPT as well as the CTBT. So after the civil nuclear deal, India secured rights to receive nuclear supplies and kept open its right to acquire advanced enrichment and reprocessing technologies through bilateral agreement. 10 years after the nuclear deal with the United States, there has been no nuclear trade between India and the United States. And India's nuclear liability law has become a smokescreen for the United States to not supply nuclear material to India. And especially after the Fukushima nuclear disaster has completely changed the global nuclear power trade, and this also has impacted India. Thus, it is because of these trade barriers in nuclear energy, the author seems to suggest that India has slowly shifted its focus to solar and other forms of energy. This topic comes within the purview of international relations of your UPSC section. An impact of civil liability law on nuclear trade becomes an important aspect of India's international relations. With this, let's move on to the next article. The next news appears on page number 9. The news reads, Getting Down to Business. This news talks about the Commercial Courts, Commercial Division and Commercial Appellate Division of High Court's Amendment Bill 2018. This talks about various changes made about this 2018 bill. So to understand the changes brought about this particular 2018 bill, let us also go through the particular act which was enacted in the year 2015. Now this particular act was covered in the Focus magazine of March issue of 2018. So let's go through the Focus magazine. After going through the Act of 2015, we'll also try to understand what are the changes which this particular bill of 2018 aims to propose. As you can see, the commercial division bench, it was covered and it stated the government has constituted these commercial courts at the district level, commercial division and commercial appellate division in the high courts for adjudicating commercial disputes of specified value. Now this word specified value becomes important. We'll see how. By enacting a law as it will free workload of regular courts in India. Now different commercial division bench had been suggested so as to decrease the workload of the judiciary, and even the Law Commission in its 245th report, as you can see, looked into the issues of creation of additional courts for elimination of delays, speedy clearance of arrears and deduction in cost. And the commission also suggested to increase judicial strength to address the issue of backlog of cases, and also to increase age of retirement for subordinate judge to 62 years, which currently is 60 years, creation of special courts for traffic and police challan cases, and also for periodic assessment by high courts to address these judicial needs. Now let us understand what this particular Act of 2015 with respect to Commercial Division Act provided for. So it reads that the Parliament enacted this Commercial Courts, Commercial Division and Commercial Appellate Division of High Courts Act 2015 to adjudicate commercial disputes of specified value. Here, two words becomes important. One is commercial dispute and of specified value. First of all, let us understand what are those cases which involves commercial disputes. As you can see, any dispute related to transactions between merchants, bankers, financiers, traders, etc. dealing with mercantile documents, partnership agreements, intellectual property rights documents, etc. can be called as a commercial disputes case. Other things also includes export or import of merchandise or services, admiralty and maritime law, construction and infrastructure contracts including tenders, and agreements relating to immovable property used exclusively in trade or commerce, distribution and licensing agreements, management and consultancy agreements, joint venture agreements, shareholder agreements, etc. Or we can say any other agreements which bind two contractual parties for a commercial agreement, and any arbitration involving commercial disputes. So in this particular act, the concept of arbitration was also there, including international arbitration, which are filed in civil courts or high court of value of more than rupees 1 crore. Now, as we said, we'll talk about this particular specified value. Let's see what this specified value was, because in this new bill of 2018, a certain amendment has been proposed in this specified value. So let us first understand this specified value. Specified value in relation to commercial disputes shall refer to such cases whose value of the subject matter is not less than rupees 1 crore. So this amount was quite steep, 1 crore, or such higher value as may be notified by the central government. Now, as you can read in this particular article on page number 9, this particular specified value has been decreased to rupees 3 lakhs in the new bill. So now whose value of subject matter is not less than rupees 3 lakhs. This is one of the first changes which has been suggested by this bill of 2018. And you can read further what are the different type of commercial courts, commercial division or high court, commercial appellate division, etc. Let us understand what are the benefits of these. It will streamline cases relating to commercial disputes and help in speedy resolution of such cases through case management hearings. Now, what is this case management? Case management is a judicial process where the judge identifies issue of facts and laws in disputes, provides a strict time frame for speedy disposal of case, and also explores alternative methods to settle disputes. Case management hearing is generally referred in cases of international arbitration. This case management will effectively help in reducing burden of cases at the level of high court. Now, speedy disposal of cases will help in improving compliance and enforcing contracts. You know that our judiciary is burdened with lot of judicial work. So all these different kind of special courts will further help in reducing those burdens at various levels. Ease of doing business. Such enforcement of contracts will also help in improving India's ease of doing business. Now, this particular thing has also been mentioned in the article if you go through it. Improving India's ease of doing business rankings, as it will inspire confidence in the business fraternity on India's capability to handle and resolve commercial disputes in a given time frame. Now, recently we know that India's rank was bettered by 30 points, and now India is ranked as 100 by World Bank on the ease of doing business. Now, this rank of ease of doing business by World Bank becomes an important piece of information, which was a jump of 30 places, as just said. It will help in creating specialist cadre of judges dealing with commercial disputes, and further it will improve judicial infrastructure at the level of district court as well as high court by providing adequate training facilities including special seminars. We see this particular act provided for settling of these commercial disputes by a separate bench or by a separate court, and it provided for a specified value. Now let's understand what this bill also aims to propose. Now, the bill of 2018 has instituted a new chapter, and the chapter is on pre-institution mediation and settlement. And for this particular pre-institution mediation and settlement, the central government may authorize authorities constituted under Legal Services Authorities Act 1987, and the authorities constituted are at national level, state level, and district level. It provides that mediation shall be completed within 3 months. That is, if a party choose to agree for mediation, then such process of mediation shall get completed within 3 months from the date of application of such request. And this period of 3 months may be further increased to another period of 2 months if agreed by both parties. And the settlement which is arrived at shall be binding on the parties. So these are some of the important changes which have been incorporated by the Amendment Bill of 2018. And as suggested, another changes was with respect to specified value of a commercial dispute, which earlier was rupees 1 crore and which has now been substantially reduced to rupees 3 lakhs. So as suggested here, this topic comes within GS paper 2 and specifically under judiciary and also relates to governance. With this, we come to an end to today's newspaper. Let's move on to the question for the day.